I will just very briefly say hello and welcome the Honorable Sarah Campbell of the Supreme Court of Tennessee. I don't want to take any time away from this panel because I know some of the things we're going to talk about, and it's going to be fantastic. So maybe I will hand it over to Justice Campbell.
Thank you, Professor Rosen. Thank you so much. It is such a pleasure to be here. I see a lot of friends in this room, a lot of really fine judges and fine attorneys, and it is just a privilege to be with you all today. I don't want to take up too much time either with introductions because I agree with the professor that this is a fantastic panel and we've got a lot to talk about. So I'm going to briefly introduce our panelists. You all probably know many of them already, and then we're going to dive right into talking about modern strategies for state attorneys general. I'm going to start to my left with Josh Devine, who is the Solicitor General for Missouri. And before that, Josh had served as Chief Counsel to U.S. Senator Josh Hawley. He clerked for Justice Thomas on the U.S. Supreme Court and for Judge William Pryor on the 11th Circuit. And you're gonna see a theme for many of these panelists as we move on with these introductions. He received his JD from Yale Law School and his undergraduate degree from the University of Northern Colorado. To Josh's left is Eddie LaCour. Eddie is the Solicitor General of Alabama and has served in that role since 2019. Edmund was, before that, he was a partner at Kirkland & Ellis. Before joining Kirkland, he practiced at a couple of other law firms. He also clerked for Judge Pryor on the 11th Circuit. To Eddie's left is Elbert Lynn. Elbert is currently the chair of the Issues and Appeals Practice at Hunton Andrews Kurth, LLP. You all probably know him well as the former Solicitor General of West Virginia. And he clerked, before that he was a partner at Wiley Ryan. He clerked for Justice Thomas, also clerked for Judge Pryor, and for Senior U.S. District Judge Robert Keaton. To Elbert's left is Stephen Petrani. Stephen is the Solicitor General for Georgia. He was with Jones Day in Washington, D.C. before becoming the Solicitor General. He clerked for Justice Alito on the U.S. Supreme Court and for Judge Pryor before that. And finally, we have Katherine Robertson, who serves as Chief Counsel to Attorney General Steve Marshall. She has been in that role for several years. Before that, worked for U.S. Senator Jeff Sessions and at the U.S. Department of Justice. So we have a really all-star panel to talk about these important issues today. And we're going to jump right in. So the title of this panel is Modern Strategies for the Offices of States Attorney General. The word modern in that title, suggests that the role of the Attorney General has changed over the years, and we all know that to be true. AGs now exert significant policy-making influence at both the federal and state levels. Has that, we think of the AG in the more traditional role as, there are certain core areas that attorneys general cover, like criminal law, consumer protection. You have this new role for AGs, at least within the past couple of decades. Has that role required attorneys general to scale back in other areas, or are they just doing more now than compared with previous decades? And let's start with Elbert on that one, and y'all just pop in after Elbert goes, and go ahead.
All right. I don't know if is this working? Do I need to press a button? Okay. Thanks, Sarah. And thank you to the Federalist Society for having me and us here. I love being back here, and the most important fact that you need to know about me is that I clerked with now Judge Brasher. And so if you want Brasher stories, this is where you should come.
He has really good ones.
Everything else I say today is not important. So to answer the question, I think the short answer is they're doing more. And I think to try to kind of put it in the context of what we all do, with the sort of rise of the state solicitor general, I think what that has encompassed is a couple of things. One is bringing some functions back into the office that had in the past been farmed out to outside counsel. And another is to add this dimension of suing the federal government every day, multiple times a day. But in terms of the other stuff, I'll just use my own boss as an example. So when he ran for AG in 2012 in West Virginia, he had this 50 things he was going to accomplish in the first 100 days, and it included all of the things that you would think about an attorney general normally doing, and then a whole bunch of other new kind of federalism-oriented things. And I can use sort of my own job as an example. As the Solicitor General, the responsibility was not just be the chief appellate lawyer for the state. It was, let's think about it in a couple different categories. There was lead the appeals for the state, manage the federal litigation, oversee the opinions, which is actually, and I think that may come up later, the opinions practice of an attorney general's office, which is really important, and then serve as an advisor to the AG. So, again, I think the short answer is they are doing more. They've added this dimension of suing the federal government, but they haven't walked away, I think, from the things that AGs have traditionally done and that they're expected to do. And I think one sort of huge example of that in the past 5 to 10 years is the opioid lawsuits, where you can almost every state AG has been in that space, and that's the kind of thing that you might have traditionally expected them to do following the tobacco litigation in the 90s. And so they're still maintaining that piece of it, very active consumer protection practice, but also doing the really important federalism piece of it.
Thanks, Elbert. Anyone else want to add to that?
I would add that the role of the SG has changed substantially over the last, I think, 2 decades. Where originally the Solicitor General was just the title that you gave to whichever civil attorney had been there the longest. And that model's not totally gone away, but most states have moved on to something else. So there's sort of a second generation, which is, the Solicitor General is a chief appellate officer. Once upon a time, AG's offices used to just, if you had a U.S. Supreme Court case, for example, you'd hire an outside law firm to do it. Now, almost every AG's office is doing that internally. And then the third role of the SG that Elbert has mentioned is sort of, there are additional offensive strategies, things of that nature that are going to come into this. It's not just appellate litigation. So technically my title is Solicitor General. It's also Director of Special Litigation. So I'm involved in a lot of trial stuff, a lot of other matters that might not even be related to litigation, but that are important priorities for the office.
Yeah, I think I've seen that in a lot of different states now. Texas is a little different because they're so much larger, and they do have a strategic litigation division in and of itself, and then they've got an SG division, I think 15 lawyers, which if you combine the SG division in Alabama with our constitutional defense division, I think we still only have about 11 lawyers total. So, but I think as more affirmative litigation was being brought by states, there wasn't necessarily a component of most AG's offices that would naturally be taking that on. And so I think maybe in part by default, maybe in part because people in the SG's offices are dealing with novel constitutional and statutory issues, it started falling to SG divisions. And so you've got these appellate lawyers who come in and have to learn how to be trial lawyers pretty quickly, but it's a fun component of the job for sure. And I think Steve mentioned the ARPA lawsuit. That was something that my division and constitutional defense, Reed Harris, who's now at the governor's office, we miss him, helped me out a lot on that, getting that off the ground and securing a win there. So yeah, but we end up sleeping less because you're doing more, but it's a fun job.
Yeah, have your staffs grown? I mean, compared to, I know you all are, I don't think any of you have been in the office more than 4 or 5 years, but I mean, just based on your historical knowledge, has the size of the staff in your offices grown over the years to reflect these new responsibilities and priorities?
I can say, and I don't know if my microphone is working or not, but ours has, even in the time I've been there. So I've been the Solicitor General for a little under 2 years, and we've gone from essentially 3 full-time attorneys and 2 kind of more junior part-time ones to now 5 full-time attorneys and a more junior part-time one. Not part-time, but like also doing stuff in other offices. That's literally in like the last 18 months. And one thing, just a very quick plug, if there are any young lawyers in the office or
Yes,
watching or
yes.
anything, like everything that they've just been talking about, that Elbert, Eddie, Josh have been talking about, it's all so much fun and there's so much of it. And no, you're not going to make anywhere near as much money as you could anywhere else, but you will never get better experience. And so you're going to get to do amazing things. And so, I think most of us are generally always kind of hiring because there's so much work to be done. People very junior get to do very interesting work very quickly. So just very quick plug there.
I'll just tap on with that. So I started as a Deputy Solicitor General right after coming off of my 11th Circuit clerkship in Missouri. So I'm, at this point, barely a year out of law school. And in the year that I was a Deputy Solicitor General, I argued 9 cases in appellate courts. I argued in the DC circuits, a bunch of times in the 8th Circuit, and the Missouri Supreme Court. And I don't know any other lawyers 1 to 2 years out of law school who are doing that. So like if you work in these kinds of offices, you can do really incredible things that you're not going to be able to do anywhere else.
Our staff hasn't grown. General Marshall just doesn't let us have any hobbies.
It's actually not true. Now Judge Brasher left, I was his deputy briefly before he went on to the federal bench, and when he left, it was an SG's office of 1. Very happy.
Small
to say.
but mighty.
Yes, exactly. People would call, "Can you do an amicus brief?" And I would just laugh and then direct them to Georgia. But we have 4 right now. We're about to go up to 5, which will be an all-time high for the division, and there will be plenty of work for them to do, as some of my staff can attest to or are here today. So,
Well, and just to explore a little bit further, all of the things that your offices do with pretty small teams when it comes down to it. Elbert, you alluded to the opinion process in attorney general offices, and I know there are so many things that your offices do other than litigation. Litigation is usually what makes the headlines, but tell us more about the other tools that you use to achieve the objectives of your office. And Katherine, why don't you start out?
Sure. I think anything we're able to achieve without litigation comes with a threat of litigation, so that's always there, right? But we found that our letterhead is pretty effective. So we write a lot of letters to a lot of different people. We write letters to Congress. We write letters to federal agencies. We file comments. And lately we've gotten into the business of writing letters to corporations, which has proven to be pretty effective. I was having dinner with a general counsel of a bank fairly recently, and he said, "What do we have to do to not get a letter from you guys?" And so we talked through that. But if you have a good idea and can put it on paper, it's pretty easy, if you're credible, to get about 15 other states to sign on to whatever your idea is. And so we've learned that is a really efficient way and an effective way to make our point, especially in the ESG space. We wrote a letter complaining about the Net Zero Asset Managers Alliance, and had 13 states on the letter, and Vanguard immediately said that they weren't really all that interested in net zero anymore and dropped out almost overnight. So you've seen that be really effective. Also, the civil subpoena power under the Consumer Protection Act is extremely effective. You never know what you might find or what direction an investigation might lead you to, but boy, when people get those, they aren't happy, and you see changes in policies pretty quickly. So we've been able to use a lot of tools. Like Eddie's talking about, we don't have enough people to file a lawsuit on every problem we encounter, but if you can solve it with a letter, you should try that first. And I think that's been really effective because we have so many states willing to work together.
a number of state attorneys general also have regulatory authority, which was a little strange for me when I learned this. But for example, the Missouri Attorney General is essentially the state equivalent of the Federal Trade Commission. We have an Unfair and Deceptive Trade Practices Act, and the Attorney General is empowered to write regulations under that act. So for example, the two attorneys general ago, when Josh Hawley was Attorney General, he wrote a regulation sort of defining unfair and deceptive trade practices with respect to human trafficking. So there's a company at the time called Backpage, which essentially was Craigslist for human traffickers. And he defined this regulation to include certain disclosures, other things that you had to do, because Backpage was, MasterCard and Visa were processing payments through Backpage without disclosures, things of that nature. And so he simply just wrote a regulation saying, hey, if you're in this business, you have to make these kinds of disclosures about the sorts of things you're doing to combat human trafficking. And sure enough, some organizations like Backpage couldn't comply with those regulations. So I think not a lot of people recognize that this is often an authority of the Attorney General, and I think in some circumstances it's underused.
I can follow up on the opinion piece of it, but there's also, maybe some other folks want to talk about this, there's the legislative angle as well, right? Working with your state legislature, one, affirmatively in advancing ideas for bills, but also in helping to make sure that the legislation that the AG's office has to defend is actually defensible. And so that's another piece of the AG's practice. But the opinion piece of it can actually be pretty influential and a pretty powerful tool. So if you're not familiar with it, it's a function that varies from state to state. In some states, the opinions have, the courts have, well, either by law or through practice, the courts have given those opinions either deference or binding or controlling or safe harbor effect. But what it is it's a lot like the Office of Legal Counsel at the Department of Justice, where a question is posed to the Attorney General and the Attorney General issues an opinion. One example, so it's a wide range of issues. When I was in West Virginia, one of the topics that we got was that we got a question from a local prosecuting attorney. So in West Virginia, that's the locally elected prosecutor for that particular county. And the question was whether they could use a particular county-owned building to turn it into a private taxidermy museum. And so that, like, we have quirky issues like that. But then we have, and this is the example that I like to talk about, really big and important ones where the AG opinion can be quite influential. So I can't remember what year it was, but I came back from traveling for Christmas break and saw in the news that, so at the time, the West Virginia Senate was, there 34, so it was 18-16, Republican, Democrat. But it was only 18-16 because after the most recent election, someone who had been elected as a Democrat had switched parties. So had been elected 17-17, so there's this whole power sharing problem, and then he just switched parties and it became 18-16. Well, 2 years into his term, he decided he didn't want to be a senator anymore, and he was going to resign and become a lobbyist for the NRA. And so this news broke, and the question was, well, what happens? So he had two more years on his term. He had been elected as a Democrat, but he had stepped down as a Republican. And so there's this question under state law, which party gets to put forward the names for his replacement? And I mentioned this sort of coming back and reading the newspaper because the narrative was, well, of course it's the Democrats because he had been elected as a Democrat. And that was what everybody was saying. They said, that's what the statute says. Clearly it means the, and so we scrambled to solicit a letter from the then, I think it was the Senate President, in the Attorney General's office. We looked at the law and we drafted a letter that said, no, we actually think it's the party at the time of the resignation, based on what we thought the plain text of the statute said. That immediately changed the narrative. There was then a lawsuit, and we participated as an amicus because they sued the can't remember who they sued, but I think they sued the governor who was going to appoint. So we participated in amicus and wrote an amicus brief that looked a lot like our opinion, participated in oral argument, and our position ended up carrying the day. And for those who are justices and judges, everybody reads the paper, right? And so, that opinion is not binding on anybody, but just getting it out there was able to change the dialogue enough so that when it actually went to litigation, we had already kind of seeded the thinking process and laid a foundation for the position that we took.
My favorite part of this story is that in West Virginia, Democrats become NRA lobbyists. I'm from West Virginia, so I just...
What about comment letters to federal agencies? Any of your offices use those to any success?
Pretty sure they go into the shredder when they're received. I haven't seen them be very effective lately, but you got to do them to set yourself up for good challenges, and so they take a lot of time and energy to write. Fortunately, again, we have a very large multi-state coalition that's very much aligned on most of these issues, but it takes time to write them, takes time to read the rule, and eventually you hope you can win your lawsuit. But it takes a lot of time, and I don't think the Biden administration reads our mail.
I think there are two useful aspects of that, though. One is typically, although not always, there's an exhaustion requirement, and so you have to raise these issues to the agency if you want to sue about it later. So it's important for that reason. It's also important for a second reason, which is some of us aren't as involved in this area, and then we get a lawsuit, and we're like, oh, let's go look at Alabama's comment letter from 6 months ago. And that can help you sort of get up to speed on the legal issues. I will neither confirm nor deny whether I have relied substantially on comment letters and drafting briefs, but they are useful.
So at least a couple of you have served in your offices or your previous Attorney General offices during both Republican and Democratic presidential administrations. Tell us how your strategies change depending on who is in the White House.
So it's certainly busier the last few years than it was in 2019 and 2020 when a lot of amicus briefs coming into my inbox supporting the Trump administration and some challenge that a blue state had brought or something else. And turning back to the affirmative litigation, there's certainly more of that now as well, and we've led on a couple of challenges, and we've joined with other states on many others, and that requires, or even if Josh is doing a phenomenal complaint and then a motion for a PI, I need to review that before it goes on file. Legally, when you're going on the offensive a little bit more, you have to be a little more thoughtful about how potential arguments as a constant defendant in many other cases could sort of boomerang back if you're a plaintiff. As a defendant, generally in favor of very strict standing doctrine. 5 million plaintiffs in Alabama, none of whom have standing, would be sort of the pitch. But when you're going on offensive, you're going to be pushing a little bit harder in the opposite direction. We obtained several nationwide injunctions over the last few years, including in a Georgia-led challenge to the federal contractor vaccine mandate. I think back in 2018, 2019, there might be some amicus briefs out there that were a little less bullish on nationwide injunctions. But it has been interesting to see the doctrine develop over the years from pre-2020 and post-2020 in the courts of appeals. But so you take what you can get depending on the facts of your case.
Yeah, I don't think that's necessarily going to be true in the future, though. So I was a deputy SG in 2017, 2018 when Donald Trump was president. And we had almost no offensive litigation. We had a couple of things that we had brought against states, or we had plaintiff side stuff against, like we had some suits against Backpage, as I had mentioned earlier. But we've seen in the last couple of years during the Trump administration, especially during the latter half, is the need for states to actually intervene in some of these lawsuits brought by some of our counterparts on the other side of the aisle. And I think that's probably going to continue to happen. They're doing it in some of our suits now that we have brought. They're intervening to defend the administration. I expect when the tables are turned, a lot of the Republican attorneys general are going to be doing the same thing, and we're going to be intervening to help defend whatever the issue of the day is at that time.
I'll add too, I think one thing we're seeing right now that you certainly didn't see in a Republican administration is, I mean, we've got the federal government in our state suing us. So it's not just, that we're reacting to all the bad stuff coming down. They're actually here. I mean, we've got DOJ here as plaintiff in 2 cases against the state. We've got the EPA involved in an environmental matter here. So they get more aggressive too. They're not just waiting on us to sue them. They're coming down and looking for ways to be on the other side of us. So that's definitely adds to the workload when you're fighting both fronts, which is not something we had to deal with a couple years ago.
If I could put sort of an exclamation mark on Josh's comment, there's lots of important reasons to intervene to defend the administration, but as he was, I think, alluding to, when it's the tail end of the administration, you have to worry about the administration flipping and then the federal government deciding to take a totally different position. And so, everybody in this room knows, right, once you've intervened, you'd have party status. And best example of this is probably the 7-year saga that was West Virginia versus EPA, right? There was a previous rule when I was there, but the most important piece of this is it was still West Virginia versus EPA because West Virginia had intervened in support of the EPA to defend the repeal. And so that is practically extremely important because, as we've seen, the administration is willing to walk away from stuff that a Democratic administration is willing to walk away from stuff that a Republican administration did.
So your client is the state, which makes things a little complicated, right? Because the state includes agencies, it includes state officials, and those officials may not always see eye to eye with one another. They may not always see eye to eye with the agencies. I'm guessing you have all encountered some interstate conflicts at one point or another. How have you navigated those? And what challenges do those present?
Yeah, so I've been fortunate, I imagine everyone else here has on this score as well, that the Attorney General that I work for, Chris Carr, is very much a rule of law absolutist. He takes very seriously, we have to not only do what the law says, but enforce the law, whether we particularly like that law or not. And so I've been spared any problems of 2013 era federal government just deciding there are certain laws that we will not defend or anything like that. But there are definitely tricky situations that you get into, especially with agency clients who are not necessarily, they're sort of repeat players in litigation, but not to the extent that the state is, that the Attorney General is. And so they might have what seems a totally reasonable desire to, say, appeal a particular decision because, well, it went against them. And we have a totally reasonable desire to not do that because we could get really bad precedent that would, go beyond this particular case, or vice versa. And I would just say that the way that I've tried to deal with this anyways is just kind of 2 basic principles. One is just sort of don't let these things happen, and then when they do, just take the bullet. And the way to not let them happen is, we are by and large appellate lawyers. If you cannot avoid deciding questions, you're not doing your job very well. You have 11th Amendment immunity, sovereign immunity, official immunity, qualified immunity, injury in fact, traceability, redressability, mootness, ripeness. There are this is almost literally the job of an appellate lawyer, is to find clever ways to achieve results that will make more people happy. And I think that we have, at least in the 2 years that I've been in Georgia, we've managed to do that in most cases. But then every once in a while, you do sort of just have to kind of metaphorically, obviously, take a bullet. And I'll just use a quick example, trying to keep it vague, because while this is all public record, the argument is videotaped and the briefs are out there. We had a case where an agency client won a decision, but actually did not want to do the thing anymore that they had won the right to do. They'd had a change of leadership, and they did not want to do that. But the other side was going to appeal it. And so we were in just a sort of an awkward position. Like, we don't want to win in the sense that, well, the agency is not even trying to really do this thing anymore, but we don't want to lose because we don't want to contract the power of the agency or contract state agency authority generally. So we came up, of course, with a mootness argument. I think it was a very correct mootness argument. 5 days or so before oral argument, the agency let us know we had a mistake. Someone did the thing that we said we were no longer going to do. So I had to go in front of the Georgia Supreme Court and say, it's still moot. I got the reception that you would more or less expect. But that was I saw that as my job in that particular instance. I still needed to make the argument, even though it was not the most comfortable argument to make, and then tried to transition into some other, there are many other reasons not to decide questions that you don't want to decide. But so to me, it's competence will get you out of a lot of scenarios like that. And I think that competence really cannot be overstated in its importance. I mean, passion and intellect and ideological alignment are all great, but competence is really the core of what you're trying to do. But then, if you really can't find your way out, and you sort of have to do something awkward, try to make it you. That's the person doing something awkward, as opposed to creating a problem for, the attorney general or the governor or the state agency or something like that.
Yeah, I would add 2 points to that. One, for the most part, our clients can't fire us. So this is a little different from the private practice. So that there is something to that. I think we have a lot more leeway in the AG's offices than somebody in private practice typically does. But to extend on to Stephen's point, sometimes you get situations where, you have separately elected state officials in different agencies or whatever, and sometimes they don't agree with each other. Just 2 days ago, I was in court arguing a motion to dismiss to prevent a county prosecutor from suing us. So you do sometimes get these situations where you have two different officials at loggerheads, and you kind of have to figure out what to do there. And much like Stephen was saying, we made a lot of arguments about standing and justiciability and redressability and things of that nature.
I'll just add, piggybacking off of General Marshall's earlier comments, there is a little tension when it comes to federal grants and stipulations that are put on federal grants, and then we're all collectively working together to try to make sure those stipulations can't be added. But if your agencies have already signed on the dotted line, it can make that very awkward, because the federal government will say, Alabama is here complaining, but do you not realize that all 5 of your agencies have already signed these contracts saying that they will do the thing y'all are saying you can't possibly do? So that can create some tension, and I think sometimes it's just because they're in the weeds of their day-to-day and they need to get their federal dollars in to run their agencies, and we're looking at it from this way bigger, state sovereignty picture that we're trying to put together this puzzle on. So hopefully you can work it out through conversations and be very persuasive, but sometimes you just got to go for it.
Well, and one of the really interesting, we've walked into an area where, right, anyone who's a law professor, it's like ripe for law review articles. Because it's a divided executive at the state level, there's all kinds of weird things that can happen when you do reach those intractable situations. You can have a situation where, stuck into Ben Flowers the other day, the Ohio Solicitor General, where the office divided itself and Ben argued against his deputy. I think he won. He represented the Attorney General, and I think the deputy represented the state agency. And that's not something that you obviously can do in private practice at a law firm, but you can. It depends on what your state laws are, right? But you can in state government. One thing that we did a couple times, if we really reached an intractable position, because we had an experience that I'm sure is foreign to folks here in Alabama. We had a governor of a different party from the Attorney General. And so there were times where the AG would authorize the governor to hire his own outside counsel, and then the Attorney General would come in under his authority to speak for the state's legal interest, and we took a different position. So that there's all kinds of strange things that happen. It's very different from the United States, where the Attorney General makes the call, right? And even when we represented state agencies in West Virginia, at least, the client made the decision on what the ultimate position was going to be. The Attorney General did not get to make that call. So again, if we fundamentally disagreed, then we just wouldn't represent them.
I can recall a situation when I was in the Tennessee Attorney General's office, and we were co-plaintiffs with another state in some multi-state litigation, and this other state had a governor of a different party, and they had to send FOIA requests to their state agency to get the information they needed for the PI motion. Have you all encountered situations like that?
I'm only halfway sorry to say that most of the people in this room are a lot poorer because of a lawsuit that Missouri won in June about student loans. It was a similar situation. We sent, in our state, it's called sunshine requests to an agency so that we could sue on behalf of the agency. Got a little bit of flack for that, but as the Supreme Court ruled, we did in fact have authority to sue under the name of that agency.
Elbert mentioned earlier the opioids litigation that almost all states, if not all, have been involved with. Years before that, there was the tobacco litigation. We have a lot of examples of multi-state cooperation on issues of national importance. Sometimes that's very bipartisan cooperation. Sometimes it's not as bipartisan. How important is that cooperation, and what challenges does that present for your offices? Josh, do you want to start us out on that one?
Yeah, I think it's incredibly important. I do think it's harder these days than it was traditionally in the past. You do see some instances. I think Franchise Tax Board against Hyatt from, I believe, 2019 is an example where you had essentially Nevada and California. California was being sued in Nevada state courts. And so you had Nevada and California had their positions, and then like 47 or 48 states signed an amicus brief saying like, you can't sue us in other states. Please don't do this anymore, right? So you do have some of these issues where basically every state is aligned. In some criminal areas, you get these sorts of issues that are bipartisan. You see this a lot with there are letters from attorneys general to Congress saying, hey, please support this bill that we all think is a good idea. So there is still an intersection of truly bipartisan issues where you will get a broad coalition of the states. I think those are fewer than they used to be, and most of the time I'm talking with Eddie and not the Solicitor General of California. And that's just how it is. And I think there have been a number of states that have withdrawn from the National Association of Attorneys General, for example, which was this bipartisan organization, out of concern that the longtime bipartisan organization had shifted its mission and was now using this mantle to do things that weren't bipartisan anymore.
I'll comment on that. Alabama was the first state to drop out of NAG, the acronym for the National Attorneys General Association. And they are a NAG. But part of that was because it's so expensive to be a member, and we just weren't getting a lot of benefit. The other part of that is I think the reality of where we are right now is, there are just very, very few issues that are truly bipartisan, and there were very few lawsuits or letters that aired on the right side of the spectrum. They all lean a little to the left. So there's not a whole lot we could support. I think another big problem with the bipartisan stuff is that we're the chief law enforcement officers of our state, and NAG really started to take a position that just couldn't support incarceration and police and things like that, which just was a huge problem for us. So NAG, we'll join a letter every now and then on human trafficking or, one of the 3 issues left that we can all agree on maybe. But I think in large part, you just see us working in blocks. They're doing the same thing. It's not unique to the Republican AGs, but they're just very divergent point of views. And I think if we're going to spend our time coalescing, we find that it's more effective to do so with the states that are like-minded.
We've been seeing with a couple amicus briefs this year, one provides a really nice control group. We've got a merits case in front of the Supreme Court that'll be heard at the end of October over procedural due process and civil asset forfeiture. And this same issue was in front of the court in 2009, but ultimately wasn't decided because of mootness. And at that time, the case came out of Cook County. Illinois AG led the amicus brief, and it was a broad bipartisan effort. I think like 20 states probably, blue and red. We have literally the exact same issue in front of the court now. Stephen wrote an excellent brief, sent it around to NAG, and I think we got one blue state.
It is bipartisan.
Yes, there is.
Bipartisan brief.
One blue state on the brief, and then 12 of our red state friends. But then another brief where we led, Troy University has a recruiting office in North Carolina near Fort Bragg, and there was a lawsuit brought in North Carolina State Court against Troy, which is an arm of the state, and they argued sovereign immunity, and the North Carolina Supreme Court held that they didn't have sovereign immunity, and they get sued, and so the state could get soaked for millions of dollars potentially. And we led a brief in support of sovereign immunity, which is probably the one thing you would think that all sovereigns would agree on, that more immunity is better. We sent it out through NAG. We got 18 or 19 states, but only red states. I got 2 or 3 tentative emails from my blue state colleagues saying, who's joined? Who's joined? I sent the list, and I wanted to say, well, such and such is on the fence too. Like, come on, everybody just make the leap together. But no one ever did. So it's unfortunate, but that's where we are right now.
Yeah, unfortunately, some of these issues that are procedural or procedural, not substantive, are viewed through the lens of okay, maybe this is a sovereign immunity case, but we really don't like what happened below. And they'll view things through red or blue lenses that way. And so you end up with these weird situations where why do none of the blue states support sovereign immunity in this case? Yeah,
and this is kind of going into an even broader topic we don't have time for, but I think there's a general appropriate mistrust among kind of red states, blue states, not because they think they're going to sneak something into a brief on a procedural issue mendaciously or something, but because so many of the disagreements at this point are not really about surface level. They're really deep. How does judging work? Kind of disagreements, and so it's almost hard for a red state or a blue state to draft a brief that is going to be acceptable to states on both sides of the partisan divide, because it's not like we have a common frame of reference, but a disagreement on how it's applied in a lot of different situations. But in this situation, we agree on how it's applied. It's just that the frame of reference has shifted so much that even if you do agree with the end result of what a brief is supporting, you're going to look at it but I don't know if I like how they're getting there. And I think that's really not good. I don't like that at all. It's beyond the scope, I think, of this, trying to reel that in, but it's a self-reinforcing thing where you just kind of see the different briefing blocks just getting further and further apart, which then breeds lack of communication, lack of trust, and they continue to get further apart.
This reminds me of, on the bipartisan issue, we used to always call Kentucky, because Kentucky had a blue AG when we were doing environmental issues, and we could always rely on Kentucky to make our coalition bipartisan. And then when a Republican won, it might have been Daniel Cameron, when he won, we were actually really sad, because there went our bipartisan coalition. But one thing that we talked a lot about, this sort of lack of bipartisanness, but another, I think, answer, Sarah, to your question is on the importance of the multi-state stuff, and Katherine touched on this, is the fact that, so within your block, right, you can rely on other states to sort of help carry the water. There's so much to do. It kind of comes back to the very first question, right? everybody here has bigger staffs than I had when I started, but it is, it's two things. One, very helpful to have all of these different people, and you can call, Eddie can call Josh and say, hey, are you guys looking at this issue? It might be more in their wheelhouse. So, for example, West Virginia does a lot of environmental fossil fuel related stuff, and that's helpful both for the optics of that state leading a coalition, perhaps, but also given subject matter expertise that they've built up over time. And then the other is just having the feeling like you're not one office, but in some ways you are on some of these issues. And it was always very helpful to know, when I was there, that I could call, Andrew Brasher and see, is Alabama, do you guys have the bandwidth or the interest to take a lead on this? Because it's not something that we can do. Texas and others, South Carolina, there were, a number of us who worked together often. And that, especially when you're talking about letters and comments and things, there's so much work that needs to be generated. It's really a force multiplier.
Yeah, I would add to that. I think last time I counted, our office has 30 lawsuits against the federal government. And, a number of these, probably about 6 or 8 of them are things that Missouri is leading on, either as part of a broader coalition or in, a case that Elbert and I are working on, it's the, we're challenging an EPA regulation as applied to Missouri and Missouri regulators. Missouri energy providers. But, I can't personally brief all 30 of these. So it's really helpful that, Missouri's going to lead on some of these, Alabama's going to lead on some of these, Georgia on some, Texas on some. But then, I'll just give a really concrete example. I just had a trial in Missouri over transgender law. We were the first state to prevail at the trial court level. Obviously, a number of states have prevailed on appeal. We were the first to prevail at the trial court level, and one of the reasons we prevailed is because Alabama was so incredibly helpful. They were first out of the gate. They helped pave the way, got to learn a lot from the arguments they made, the amicus briefs they were doing. And so by the time it got around to us in Missouri being sued, about a year and a half after Alabama was sued, there were a lot of different things I knew to try. There were areas where I could learn from the experience that Alabama had taken, some of the things that might not have worked for them, some of the things that did work, and you really can just share this expertise.
I'll add to one thing I think is interesting is sort of how the issues shake out amongst the states and how different states sort of build up expertise. I mean, West Virginia crushes it in the EPA space, but I think when we look at sort of the national landscape and where we're going to jump in, Alabama has, obviously all the attorneys general are elected. We have the voter base to support us in doing some of the hot issues, right? And not every Republican AG is situated that way. And so we sort of take that as a mandate. If there's something that's going to be kind of tense for one state, we can do it, and we try to do it. And I think in that regard, we try to provide sort of a right flank for the group and give our group cover for things that we feel very comfortable filing, very comfortable saying that might be more difficult for some of our other colleagues.
Yeah, I think a great example of that was litigation over the Equal Rights Amendment, which if you're around in the 70s and the 80s, you might remember that, but there's a big push to amend the Constitution. There was a 7-year time limit, though, after Congress sent the amendment out to the states, and I think 35 of 38 states ratified before the time ran out. And then everyone basically agreed, amendment dead, not a thing, not in the Constitution. Until a few years ago when some law professors thought, well, maybe that 7-year time limit doesn't really count, and we can just get 3 more states to ratify, and with an equal rights amendment, then we could have a constitutional hook for abortion, for taxpayer-funded abortion, for men playing women's sports, et cetera. And 3 states then purported to ratify well after the time limit had run. And someone brought this issue to our attention. Well, we don't want the Constitution to be hijacked, but at the same time, it's not necessarily a popular thing, or it's an easy attack line to say, well, Steve Marshall is anti-woman. No, we're just pro-Constitution. And so, Steve, we talked about the issue, he agreed that this was something worth fighting for. And I think we were only able to get about 2 other states to join us initially, but we brought suit. The Trump administration put out an OLC memo saying, no, we agree with you, Alabama, this thing is dead. And then blue states sued in DC, and so we intervened in that case. And because we were there, we were able to brief the merits issues when the Biden administration was only briefing standing, and ultimately got a merits ruling from a fairly liberal DC Circuit panel that I think has helped to keep the Constitution from being hijacked, at least for a little bit longer.
So we've got at least a few law clerks and law students, I think, in the audience. I know a couple of your offices are hiring. I would venture to guess everybody's probably hiring.
Always.
So why don't each of you give your elevator pitch for why should these talented young lawyers come and work for you?
Well, first, as sort of the black sheep, the only state that's not represented in the 11th Circuit, I would say you should come work for Missouri. Like I said earlier, in basically just over a year as a deputy solicitor general, a year out of law school, I argued 9 appeals in the DC Circuit, 8th Circuit, Missouri Supreme Court. I was second chair in the U.S. Supreme Court, and you just can't do that anywhere else. I know appellate partners at law firms who have fewer arguments than I got in 1 year. So if you're looking for an area where you can really cut your teeth and do actual legal work at a really intensive, cool level, if you want to practice constitutional law, if you want to do any of these sorts of things, it's really the state governments where you're going to be able to do so.
Yeah, I don't have a lot more to add to that. I see my former deputy, Taxi Wilson here, he argued in the 11th Circuit on back-to-back days, which is something I haven't even done yet. And because we are small staffs, responsibility gets pushed down dramatically. My assistant SG, Soren Geiger, who started this week, has an 11th Circuit argument coming up in a week and a half. So he still has to get admitted to the 11th Circuit, but I think that's coming today. And then you're working on stuff that is, of course, in the news, and it's exciting to see stuff that's in your Twitter feed show up in your inbox. And we were actually coming back from one of Taxi's arguments. He said, do you think you might go back to private practice at some point? And the thought I loved my time in private practice, but after getting a taste of this, the thought just made me sort of sad. So it's so much fun. You would not regret it.
Yeah, I would just, to sum all of that up, I would just say it's objectively better than law firm jobs in every way except one. And on that one, I'm actually going to steal from Josh, who's a very good friend of mine. And when Josh was done clerking on the Supreme Court, so as most of you know, you can go to a law firm and make just an ungodly amount of money just in a bonus. And Josh did not do that. And I was kind of blown away by this. He went back into public service immediately. And Josh just said something that has always stuck with me. He's like, well, I haven't made decisions in life thus far based on money. I don't want to start now. And that I would just think about that when you're trying to decide what to do with your career in life. And it's not to say you should not go into private practice at various points and whatever. And there's lots of good work to be done there, and it's important. And I'm not denigrating it or anything, but just try not to make decisions based on money when you don't have to. It's really it's a privilege that a lot of us have. Most people kind of have to do the thing that will make them the money that they need to survive. And if you don't have to, then try not to.
So, as the only person in private practice, I feel like under the debate rules, I get 30 seconds to respond. Look. I think I would echo everything that they said, but I would, being the person in private practice, I would say a couple things. One, there is life after the state SG job, and it can be.
But is it sad?
It is. Do I look sad? No, I can reaffirm, I guess, what the folks here have said, and Katherine, I know I jumped in front of you, but because I wanted to defend private practice, but it is. you can go, so I would say everything they said is exactly right? And I made the move myself. I was practicing at a firm in DC. The opportunity to be the West Virginia Solicitor General kind of fell out of clear blue sky. And it is the second best job that I've ever had, right? The best job I ever had was clerking for Justice Thomas. But after that, being the state solicitor, I mean, what I do now can't hold a candle.
Third best job, maybe?
Yeah, right. I might have gotten disinvited from future conferences. But it is, all of the experience that you get being a state SG, is exactly what these guys are saying, kind of sort of looking back on it, right? I mean, I had something like 24 arguments in the years that I was there, which I would not have gotten, right, if you think about the alternative universe, Elbert. He'd still be sort of, scratching and clawing for, to get to 10, right? And, but the one thing that I did want to add is, if you do want to end up going back into private practice, it's not just that. I got some really good advice. I don't know if Kevin or Judge Newsom is in the room, but I called him before I took the job, and he had been the Alabama solicitor. And one of the things that he said is, not only do you get to work on these really cool cases, and you get to do all these arguments, but it can also turbocharge your career in the sense that, as the state solicitor, I mean, you speak for a state, you lead these large coalitions, and you right up there next to at that time, right, it was the Peter Kaislers of the world, and today it'd be the Cannon and Paul Clement and whoever. And then you come out of that job and, have the opportunity to continue to work on really interesting things. So, not everybody may want to go back to private practice, but I do think that there is life after being in state government, and if doing this job is a really good detour along the way.
Just on the topic of hiring, we're always, looking for good talent. I'm reminded when I used to work for Jeff Sessions, we would regularly come to the law schools and interview for our one-year clerkship, and the first question we would always ask is, how conservative are you on a scale of 1 to 10? And if you didn't say 11, you didn't get the job. So if you want to work in the executive division of Steve Marshall's office, you better actually believe the stuff that we all say we believe, because it can be tough if you don't, and then you won't last long. But as far as the pitch, other than being conservative, when I think back, I've been in my job now for 6 years. When I think back on all the stuff I've done so far, and all the things I want to do. I mean, we have 16 divisions, and I've had a kind of a goal in the back of my head to do a case with every division in the office. I've only got 2 left that I haven't done. That means consumer, criminal, appeals, capital, environmental, you name it. I've touched at least one case in every division, which is remarkable. And I'm an adrenaline junkie, so that's why I keep doing it. I mean, where else could you just dip a toe into the most exciting thing that your office is doing that day? So highly recommend it if you're a true believer.
Well, and I'll step outside my moderator role for a second and just say one advantage too, when I was in the Tennessee AG's office, I had the good fortune of getting to know everyone on this stage, and it really, the community of attorneys in state SG offices and AG offices is really remarkable. They're very talented. And I think it's an opportunity to move back to your home state, or not your home state, but a great state to live, and still have that national network. Which is important, when you do make the jump to private practice down the road or whatever the next step is. It's a really fun job.
I think maybe every one of our SG cohorts, with the exception of me, is on a bench somewhere now. So I get to argue in front of my friends, which is great.
And you're making a lot more money than us. I think we have a few minutes for audience questions, if there are any. Go ahead. Do we have a microphone? There we go.
So I think you mentioned the student loan case. So that style of Nebraska v. Biden, the standing argument was mostly based in Missouri. How do you decide who gets those arguments, who gets, front billing on the case? How does Nebraska get the argument when it's based in Missouri?
Yeah. So that case was actually brought in Missouri District Court, right? I've been asked this question a number of times, and the short answer is, I wasn't here. I wasn't in the SG's office when that case started. I was still working in the Senate. But my understanding is basically the conversation goes, we're really busy. How busy are you guys? And they're like, we're really, really busy. So you kind of make the call based on that. Like I said, we have something like 30 lawsuits against the federal government, and a lot of times it's just, hey, we'd love to do this, but we've got a trial upcoming, 3 weeks from now. We just don't have the bandwidth. What does your bandwidth look like? And that's the same situation with the student loan case.
Everyone is very collegial except for Texas.
Any other questions? All right, well, please join me in thanking our exceptional panelists.